It's unlikely that any circuit in the country has produced as many police dog-related rulings as the Ninth. Mendoza v. Block, Chu v. Gates, both came out in 1994. Watkins v. City of Oakland in 2003. Lowry v. City of San Diego in 2017. Rosenbaum v. City of San Jose in 2024. And Ellis v. Pierce County in 2025. And together, they form one long weather system in K-9 law. A bite that continues after surrender can violate the Fourth Amendment. In Mendoza v. Block, the Ninth said that a bite is lawful at the start can become unlawful by duration. Chu v. Gates, they reaffirmed that idea. Watkins v. City of Oakland, they held that failure to recall a dog after surrender can be excessive force. Then came Rosenbaum v. San Jose. Officers responding to a domestic disturbance in San Jose used a K-9 to find a man hiding in an outbuilding. Within seconds of contact, he surrendered. He laid flat and extended his arms out. The body-worn camera showed that the dog was biting for roughly 30 seconds before release. At oral argument, Kendra McKee, counsel for the city of San Jose, opened this case by stating, "This case turns on the second prong of a qualified immunity analysis, whether the right at issue was clearly established such that a reasonable officer would know that his conduct violates the Constitution." Unquote. A judge asked, "I did not see an argument by the city that those officers should be treated differently. Perhaps Officer Dunn, there's a different analysis because he was the officer in charge of the dog, right?" McGee, "That's correct, Your Honor. This entire case turns on the actions of Officer Dunn because of the excessive force in this case, as a reminder, is the duration of the dog bite. That established scope. Deployment wasn't the issue here. The time was." Another judge stated, "The holding in Watkins, which the officers are presumed to have read and understand and guide their future behavior, is that once the individual who is being arrested has surrendered and is under control, you cannot continue the bite." McKee replied, "You cannot keep a dog on an attack as long as the suspect is fully surrendered and the word here is very important, under complete control." The judge pressed on. "So your position is that the individual wasn't surrendered and under control until he was handcuffed?" McGee, "That is, in fact, our position." The bench wasn't persuaded. Another judge countered, saying, "He's lying prone on his belly. The video shows that the dog has stretched out his arms. There are officers with guns pointed at the suspect, and he contends from there on that there's another 20 seconds or more in which the dog continued to bite. Why isn't that enough to at least let a jury decide whether he had surrendered and was under officer control?" The counsel for Rosenbaum answered, "You can see his hands throughout. His hands were never ever hidden from the officers. From 10:51 through 11:19, nearly 30 seconds, the bite continues. The entire time, Mr. Rosenbaum's arms are outstretched and in front of him, and he's in a prone position. He never tries to stand up." A judge summed it up by saying, quote, "The rule is that once somebody has surrendered and is under control, then you've got to let the dog go. There's a timing factor there, right? So that can happen on second 5, and then there's got to be some period of time for an officer to recognize those circumstances and call the dog off." McGee closed by stating, "The court has never defined what quote-unquote fully surrendered and under control means in this context, and for that reason, Officer Dunn is entitled to qualified immunity. That exchange is at the core tension of the Ninth Circuit's K-9 law. Judges say the rule is clear, and the city says the definition is not.